hey, I'm just trying to do the best thing that's for you. That's the only thing I care about here.
And principal is expensive, and it's not a good way to make those types of decisions. You need to really turn on your business brain and think about what makes the most sense.
I'm reading this and I'm like, who did this? Who crossed this out? I can't understand why you as a buyer would not want to get a title policy. That's like crazy.
People who feel empowered by things like ChatGPT or Claude to try and practice law pro se, so they want to represent themselves, which is fine, it's their right, but it creates a lot of misunderstandings and a lot of confusion about what people are actually entitled to.
And this is timely. This is timely because this is new in society.
This is one of the things that folks struggle with mentally is they don't like talking about death and they don't like talking about incapacity, but it's coming for all of us. So you might as well start now.
Well, I think this is interesting because who knows, someone might stumble upon this and they'll be able to hear a perspective. Someone might be considering being a pro se ChatGPT person, and then they hear you and they're like, okay, well, no, maybe I'll reconsider that.
Someone files a partition and you are not the surviving spouse of the person who has died. There is no point in fighting it. There's just none.
Welcome to the Texas Probate Real Estate Podcast. My name is Jeremy Kritt, and I'm the owner and broker of Kritt Real Estate and the founder of Texas Probate Real Estate. On this program, we bring to you professionals in the probate space to help you manage one of the most difficult times that people face is when someone that we love, that we know passes away, and now we're settling their affairs. And a lot of times it involves their house and selling one of the greatest assets that most Americans own. Today, we have Caitlin Haney Johnson, and she is a litigator in the probate space. I want to really welcome you to the program today.
Thank you so much for having me. It's a pleasure to be here.
I am really looking forward to our time together because we have not had any attorney on that is really focused on litigation. And this is going to be very interesting for me personally. As a real estate broker, usually things are a little bit more resolved by the time that they're going to sell the house, right? So they've probably gone through your machine there to work it all out. And so this is going to be very interesting. Before we get into the core of what you're doing and what you can share with us, which is, I already know it's going to be pretty amazing. Tell us a little bit about yourself. Tell us a little bit about where you're from, where'd you grow up? What did you study? How'd you get into law? Tell us a little bit about yourself.
So I am from Austin. I grew up in Austin. I left for 8 years for college in AmeriCorps and then law school and then moved back. My story is a little bit unusual in that I am a second generation attorney, but from the mom side and not the dad. So the joke is that I actually went to law school twice. My mom got pregnant with me when she was in law school. And so I very politely waited until she was done with her finals of the fall semester of her third year before making my entrance literally the next day. So I understood the assignment. So the law has always been part of my life. I loved having a lawyer for a mom growing up. We're at a different, back then there were quite a few women lawyers, but it was still very unusual compared to today where I feel like women may even outnumber men, but I don't know. So after I came back from law school, I joined my mom's law firm with my sister, who is a paralegal and who had worked with my mom since about 2001. So when I moved back in 2013, I joined as an attorney. And we got to work together for 8 years and it was wonderful. Unfortunately, my mom got a brain tumor and died in 2021. And so my sister and I are continuing her legacy and continuing to keep the law firm running along with another paralegal who's been with us for about 8 years. So it's very much a family affair. I like to tell folks that I've lived what they're going through and that I know what it's like to face down a diagnosis unexpectedly, to suddenly step in as a caretaker for their family member or their loved one. Overnight, I found myself in charge of a law firm, which obviously had a lot of growing pains and learning curve associated with that. So my mom was primarily a business litigator. She did a lot of business divorces and that type of work. So there was some fiduciary aspects to it, but was primarily a business litigator. But she did do kind of one-off estate planning and probate for friends and family. Our practice started to shift in around 2014, 2015. I was actually diagnosed with cancer as a young adult. Luckily, my treatment was relatively easy. By the time I'd had surgery for something unrelated, pathology came back with a cancer that we didn't even know existed. but it was gone before we even knew it was there. But obviously, as a 27-year-old, that rocks your world a little bit. And so I started giving free estate planning, like learning sessions to different cancer support groups, and eventually applied to speak at CancerCon, which is the largest young adult cancer survivor conference in the country. So I got to speak there a couple of times about estate planning and what that looks like for young folks specifically, because people often think about, the wills and that kind of stuff, but there's a whole lot of stuff that goes into it beyond that, like powers of attorney and things of that nature. So when I was doing all this speaking, naturally, our practice just came to have more estate planning in it because word was getting out that we were doing it. We started advertising that we were doing it a little bit more. And then I had my first contested probate in 2016, and I just fell in love. I thought that it was really interesting. It was a good case, and I had represented a terrific family, so that always makes it easier when your clients are the good guys. And so I just fell in love, and ever since then, we've been doing it. So right now, I would say our practice is about 30% estate planning, 30% uncontested probate, about 30% contested probate in some form or fashion, whether that's a dependent administration or full-on litigation, and then about 10% miscellaneous.
Okay. Very interesting. Well, very interesting background. I totally get the growing up in like a law family or a parent that is doing what you're doing. I have a very similar experience. My mom and my dad were in real estate for 30 years as I was growing up. And so in a roundabout way, that's how I am where I am today, And by the way, kicking and screaming too, because I never thought, I was like, no, I don't want to do real estate. That's what my mom did. I remember hearing all about it growing up. So totally get it. That's very interesting. And it sounds like you've gone through a lot just as a young adult with cancer that I can't even imagine. That's actually very, very scary.
But it is part of life. So that all kind of transformed into me co-founding a pro bono estate planning clinic. So if anyone ever has heard the words, you have cancer, you probably qualify for it. It's held twice a year in Austin.
That's very interesting. Okay, we'll put that in our show notes. We'll put information about that. That's very interesting, and we definitely want to share that. I'll put it on my blog as well, just so that Google will pick it up. So that's great. Not that we're that influential at Texas Probate Real Estate, okay? But we'll put it on there. It's our little thing, okay? All right. I want to move now into probate litigation. Caitlin, I got to be honest with you. In my work as a real estate broker that is very niched down into helping families, executors, administrators, heirs sell property going through probate, I have witnessed a lot of things. Sometimes it's very easy. I have right now as I speak, I actually have 10 different deals going on that are real estate transactions that are a result of probate. And when I think about all of those cases, those situations, some are very simple. Dad passed away. There's just him and his sister. We're trying to get the best we can from the sale. They're going to divide up the proceeds. Done. Easy. And then I've had other ones where obviously it's not my business to get into all of their personal matters, but I can I can tell there's a lot of tension, or they're telling me about it. They're worried about, like, even during the sale. I've had some executors like really worried, which, by the way, Caitlin, I'll tell you something interesting. That's one of the things that I think is important from a real estate perspective of doing a sale in a way that's defensible, that if something happens and something comes back, we have a file that is clear, that is, makes sense, that when someone looks at it, people can understand the decisions that were made. A lot of people don't realize that, but with these kinds of sales, that's important. And so, yeah, some of these, it's just like, it's almost like we're on eggshells because they're worried about other people in the background, not trusting them, or they have conflicts from the past that have resurfaced. But let's go to the very, very beginning. A client is approaching you to hire you. What does that look like in these contested situations? What are the main issues? Is there any patterns or commonality that you see?
Well, I don't think it would be shocking to learn that blended families tend to be more difficult, or families where we have half siblings dealing with each other instead of the siblings that grew up in the same family unit. There's definitely a lot of the type of tension between stepmoms and stepkids, or stepdads and stepkids, that I think most people are familiar with in some form or fashion. And so when they come to me, it could be a variety of things that's going on. We could have folks who are now find themselves co-tenants of a property, or co-owners of a property that they had no intention to co-own with, and there's disagreement about whether or not to sell. If they are going to sell, who's going to be the representative, how we negotiate that when we're dealing with people who don't like each other. There may be people who want to force a partition when we have folks that co-own a home together. Or it could be that we don't agree on who should serve as the administrator or the executor. And so we're trying to decide how we can best deal with that particular issue. That comes up quite a bit when we have step siblings and they both want to serve as executor because someone has appointed them as co-executors, which is a different topic. Or sometimes we have folks that think that a will is invalid. I had a situation where, the decedent, our person who passed, left everything in like a handwritten note to a caretaker who was like shocked. And so now we had to deal with this because there was a house and it was a whole deal. So maybe we do will contests where we say that a will was the product of duress or the person lacked capacity. There are all sorts of these types of issues that come up. So sometimes it's who's going to actually get the property. Sometimes it's who's going to be in charge of administrating the estate. And sometimes it's what are we going to do with this property now that we know who owns it and we don't have an administrator or an executor who can sell something.
Now, I'm picking up on something on what you're saying. So you've said something multiple times. It's the word properties. I'm not hearing bank accounts. I'm hearing real estate. You're speaking my language here, Caitlin. And this is one of the things I'm kind of passionate about and that I really like about this area, because at least what I've found is that, there are some high net worth individuals that have a lot of assets beyond the home. But at least in my experience, or maybe I'm just too poor, I don't know. But at least from what I see, the vast majority of these estates, the house is really where a lot of that equity in the estate is. Not just equity in the home, but the equity of the estate. It seems that is where, for most people, that's where it's at. And that's where a lot of the contention comes in, because they've got this big asset and then selling it's a big deal. And there's a lot of decisions that go into selling real estate. So that in itself, can bring a lot of pressure under normal circumstances, not just this kind of thing. So am I hearing you right that a lot of times this is revolving around the real estate primarily, or not?
I mean, it just, every family is a little bit different.
Okay.
I will say the thing that makes real estate more challenging is that there can be emotional attachments to real estate in the way that you're not emotionally attached to an IRA, and that it is just, practically speaking, more difficult to divide up. So, just last Monday, I was in a mediation where we're trying to divide up a family ranch, and, each 20 acres is a little bit different. So how do we deal with trying to make that equitable? So it's one of those things that it's more difficult. People will certainly fight over cash, but it is a different dynamic when we're talking about something, especially if it's something that holds a special place in someone's heart.
Yeah, absolutely. Absolutely. So they come to you with their problem, and I'm assuming that from there, the first step, after you've understood what's going on and kind of what the objectives are, I'm assuming you're trying to mediate the problem before you go into any kind of trial situation. How many of these things go to like a court and, we have to sit through a trial and really fight it out? And how much of it really goes to maybe just a less formal kind of venue like mediation or arbitration or something like that?
So the vast majority of things settle outside of court. That is especially true when both sides are represented by an attorney. One of the interesting issues that has come up in my area of law specifically is people who feel empowered by things like ChatGPT or Claude to try and practice law pro se. So they want to represent themselves, which is fine. It's their right. But it creates a lot of misunderstandings and a lot of confusion about what people are actually entitled to. Those cases, by and large, we have to go to court and have a judge decide what is what, because there's just there's a lack of education that prohibits folks from understanding that it's in their best interest to settle. Yeah. And, the way I like to think about it, your average attorney's hourly rate is $400 an hour, or more in situations like this. They can easily be $500 or $600 an hour. Mine's not, but other people's are. And so, okay, you're upset because you don't want stepmom to be reimbursed for an HOA fee that she paid for, a couple of years. And so you're going to file a big old motion and drag us all into court to fight about it. Well, I get paid off the top. And so, these attorney's fees add up really fast. And it is very easy to have situations where I get more money than the heir does at the end of the day. Because, if there's only couple $100,000 in equity and we got 4 or 5 folks that are going to be splitting that, and my fees are the biggest on the top because we're fighting over things that we shouldn't be fighting over. It's really interesting how people aren't able to conceptualize that and understand that they're going to end up with less money in their pocket at the end of the day.
You've really touched on something very interesting. I've experienced this in my own work. I very recently, I've had a few situations where this is a little bit different, but I'll address kind of what you said regarding, the legal situation. I'm in a listing appointment, right? I'm doing my thing. Yeah. I'm pitching my prospective clients and, we're walking them through my process. And of course, all of this is leading to trying to get them to sign the listing agreement, of course. And I've people, I'm explaining I like my go-to is just to, go through the agreement, right? Explain the agreement to them, what we're doing. Okay. And I've had people, they just stop and then they just take a picture of the agreement. Then ChatGPT is giving them all these questions. And it's very interesting, because for myself, I'm basically I'm a real estate expert. I'm a real estate broker. I own my own firm. I know these things inside and out. And, those agreements, they're very general. They try to account for, a lot of different situations. Many of them won't apply to the individual, And so, so they're asking me all these questions, and then ChatGPT kind of interprets it as like we're in almost like it's an adversarial, like, oh, you got to be careful about this, and it asks me all these questions. And I'm like, well, these things don't apply to you. Your property isn't this, so it doesn't matter. And so we're spending all this time objection handling over things that are really just kind of nonsense. And and then I'm actually just trying to help them, to do what they want to do. And then what I found is that it just doesn't have the context. It just doesn't have the transaction experience to really understand, so it's almost like you're starting from ground zero, with this agreement that's in front of you. And it doesn't have the context of who I am and what I'm doing. And so I noticed it does two things. One is it makes people overly confident that they know what's going on, which I think is what you're expressing here. But also it can lead people to make poor decisions or to do things that are really not in their interest, like stalling, being, it's like I'm telling them one thing, which is an expert opinion, it's expert advice. And by the way, I'm a fiduciary to the client. So, I have a very high standard with my clients, right? So I am looking at this from the perspective of, hey, I'm just trying to do the best thing that's for you. That's the only thing I care about here. But then ChatGPT is it's like Uncle Joe in their ear telling them this is wrong or whatever. And it's very frustrating. And in some cases, it can hurt clients to make, bad decisions. So, is that kind of how you feel about it? Is that what you're seeing?
Yeah, I think that it is helpful in some ways, but it is not a substitution for someone who's done it 100 times a year. You know what I mean?
Yeah.
I pay for a higher end legal generative AI software to help me, quite frankly, break down these ChatGPT motions that are 40 pages long that I literally cannot understand because they don't make any sense. And even with that level of sophistication with the AI technology, the kind of saying within the lawyers group is, it's about as good as a first year summer associate. So rely on it about as much as you would a first year law student writing a memo. Trust but verify. They're going to be imaginative. They're going to bring up something that doesn't quite make sense. So, but it can be useful for just getting a basic overview of information. And then in my private practice, I'm even having some clients taking their estate planning documents and running them through these legal software. And I have to explain to them, these AI platforms, you're taking my work product that I've perfected and has spent the last 15 years really making it fit for what I think the right, for the family. And now you're using it to teach AI. That's really, it's not the same. And you're now using my work product and giving it to someone else who's not paying me for it. But that's, another thing.
That's actually very fascinating. That's interesting. Yeah. Cause it is an intellectual product, right?
Yeah.
That's actually very interesting. Yeah, people don't think about that, right? They just put it in and, they don't think about it. I guess another thing, I read something very interesting that things that you put into these platforms are not protected. So like these can be subpoenaed. And so that's actually a problem as well, right? Have you had any of that with your proceedings?
Not yet, thankfully, but I have adjusted my engagement letters to address that specifically,
Oh,
where
interesting.
telling them not to do it and telling them what the dangers are. Just like we had to put that stuff in there about social media, when that was a big thing. Like, don't post about your case on Facebook. It seems like that should be something that everyone would know, but people want to feel validated. So it's similar. It reminds me a little bit of the early days of social media when we were having that issue with clients.
Okay. So kind of coming back, what I'm hearing you say are things becoming a little bit more litigious because people are they can just kind of produce these so I'm thinking before ChatGPT, right? So if I wanted to write, and I know what these motions, what they look like, I have a sense of how they read. So, before something like ChatGPT or Claude, that would be very hard to construct on your own because it has a certain format. It's got, you got argumentation in there. Maybe you have, cases in there to make your argument. So it's like a very high level term paper or something, Is there more litigation, or do you think there's going to be more litigation, this pro se litigation, because it's just so easy to whip something up? And I'm assuming that when the court gets it, they have to at least read it, right? They have to consider it. So is that where we're going?
I think for our smaller estates, like what you're talking about, the estates where the home is the only asset, we're seeing that more and more, which is sad in a way because, that pot of money is never getting any bigger. We're never going to have more than $200,000 in equity in this home, right? It's only going down. And it's before people may object, but they just show up to court and it was pretty easy to deal with it. But it definitely has empowered folks to think that they can actually do a full-blown trial as opposed to just showing up to the court and saying, I don't like this. I do think that it has made it where more people feel more comfortable objecting to something. I know you've had previous guests on the podcast that have talked about the importance of an independent administration. And we had a case recently. I have a case where one of the sisters asked ChatGPT, should I consent? They all get along to an independent administration, and whatever software she used told her that dependents are the default and what most people in Texas go for, which is banana land. It's banana land.
Yeah.
There's absolutely no reason to have a dependent administration, and if you can avoid it. And so she objected, not because she didn't trust her brother, but because ChatGPT told her it was a good idea. Whereas before, I think people would pay a couple $100 for a 30-minute consultation with an actual attorney who would explain to them, oh no, like unless you think your brother's going to do something nefarious, you're much better off going in the independent route. So
Wow.
I think that's where it's taking it away is before. I can't tell you how many consultations I have where someone calls me because they want to contest a will or they think their brother, the administrator, is doing something wrong. And in a $300 consultation where I'm reviewing all the documents beforehand and then talking to them later, I've explained, this is all actually normal, or that's really not what will contests are for, and your chances of success are very low, and the amount of money you would spend pursuing that case is not going to make it worth it. That they say, okay, and they move on and they're out $300, but that's a lot better than using these tools that are telling you that you have a good case, and then 3 years down the line and $100,000 later, you realize that ChatGPT is not your friend.
How does the court take it? So like these judges, when they get these motions, like, are they just like, oh, okay, here we go? Or like, do you have any insight into how they take it?
No, I'm not a judge, but my general understanding is that everyone is frustrated. No one has a problem with someone advocating their position. The problem is the sheer volume of these motions. My average motion is less than 10 pages. I'm talking 40, 50 motion or 40-page motions with 100 exhibits attached. And the exhibits are nothing. The exhibits are pleadings. That's not evidence. That's pleading. But they don't understand that. And so it's the sheer voluminous of it that is, because it just takes time to read it. To your point earlier, we have to read these things. It'd be malpractice not to.
Right. This is actually fascinating. This is timely. Because this is new in society. But I think what makes it interesting, as a non-lawyer hearing this, when you're engaging the legal system to try to do things, like it can have very significant consequences. It's something that's on record. It's, it's there. And so it's a little bit different from my thing, which is it's kind of an annoyance versus this has like very serious, could have potentially very serious consequences. And I can imagine maybe even if someone has a real case or a real something really, something to it, to what they're doing, they might even mess up their chances, right? Because they're doing all these things and now it's already, all the stuff is submitted to the court. They've done things incorrectly. And so now if a lawyer came in, they'd probably be like, well, I can't help you. This is just, this is convoluted or something.
It definitely could. And it can create situations where people lose the opportunity to make arguments they otherwise would have been able to make. And then it also just creates a lack of good faith where, if you try and do it by yourself for 2 years and then a lawyer comes in, the other lawyer is going to be relieved, but the judge may be annoyed at this point. I don't know. I'm pontificating, but.
Yeah. Well, I think this is interesting because who knows, someone might stumble upon this and they'll be able to hear a perspective. Someone might be considering being a pro se ChatGPT person, and then they hear you and they're like, okay, well, no, maybe I'll reconsider that. I think something that's interesting that's happening in society in general is that, a lot of people are trying to do things cheaply. They're trying to do it yourself. There's not a value for professional knowledge and professional experience. There's a trend to like commoditize it, or people are viewing it more as a commodity. And it's challenging because for professionals, like for you in your field, me in my field, even doctors are dealing with things like this. We come at it from, it's not just you went to school or you have a license. It's that, no, I've done hundreds of cases. I've seen, 20 different permutations of this problem, right? And so I understand like a strategy for attacking the problem that you may not have because you just haven't had the benefit of seeing this from a lot of different angles in real life situations. And I think it's important. I think this is actually going to be very useful potentially to someone who might stumble upon it, to see like this is something you might want to consider. But, I'll tell you a funny story. I had a past client who's very, very wealthy, a very high net worth individual, millions and millions and millions and millions of dollars, both in assets and liquidity. And he was buying his neighbor's property, acres of property in Central Texas. And, I sold his property in the past. His wife passed away. He's just kind of doing his thing. And he was doing a deal with his neighbor. He didn't feel he needed an agent, which is fine. That's fine. It was kind of like, like they know each other and, it's kind of, the formalities of the paperwork for them is kind of how they looked at it. So, but, he called me and he's like, hey, Jeremy, he's like, I want to ask you a question because some things didn't feel right to him. So he's like, Jeremy, okay. So I'm like, yeah, of course, my past client. So of course, right. So yeah. It starts on Facebook, right? Hey, Jeremy, like, okay, well, let's talk on the phone, right? So we're talking on the phone. These are on the promulgated forms, so I understand what's going on here. Yeah. So he sends me over the contract, and I'm just like, for me, it's just kind of like, okay, here's another real estate contract. I'm looking at it, and then I'm seeing like all these red lines across like things that are very important to a buyer, like a title policy, or like things like this. I'm reading this, and I'm like, who did this? Who crossed this out? Because I can't understand why you as a buyer would not want to get a title policy. That's like crazy.
Yeah.
And I kind of explained to him what a title policy was, why he should get one, blah, blah, blah. And he's like, well, my neighbor's attorney created this contract. So now it's becoming clear, like what's going on, right? He's representing the other guy, But it didn't make sense not to get a title policy, but that's another matter. But there was other things in there. And I said, look, I'm not representing you as your broker here. Unless you want to hire me, I can't really help you here. But you may want to talk to an attorney. You may want to, look into this a little bit more carefully. But I told him, hey, you know what? I really do recommend you get a title policy. I recommend that you do get a survey. This is like real estate 101. This is like when you're getting your real estate license, like the first things you learn. Okay. And then he told me something interesting. So, because I know a lot of probate and estate attorneys by doing this. And he's like, yeah, I was thinking about this guy do a trust for me. I'm like, wow, if this is how he does a real estate contract, I don't think you want him doing your trust. So I recommended him to an attorney that I know. But here's the point I want to make, and hopefully he's not watching this, but if he does, it's okay. We have a good relationship. I recommended him to an attorney, on actually one that I've had here on the show, and he didn't hire him. And I know this attorney is like, just like a really good person, very experienced. I mean, I would have him, I would hire him. I totally trust him. Real legit attorney. He didn't do it because he felt it was too expensive. I don't know exactly what the fee conversation was, but I know the people involved. And I'm absolutely positive that whatever fee was charged was reasonable for whatever it is that he was going to do. And I'm thinking, okay, you've got these like millions of dollars of assets. You've got this big thing going on and you're worried about your family fighting over it and this and that. And you're worried about this fee, like, which is going to be like way small compared to the size of this estate. And he didn't do it. I don't know if he's trying to do it himself, but anyway, he doesn't want to spend the money. He doesn't want to, right? He wants to be cheap. Right? Everyone wants to do it cheaply. And it's like, people don't understand, like, it's dangerous. It's actually dangerous to do this, especially, the higher you go in your net worth and the assets you have. I mean, just pay the fee. It's the cost of doing business,
Absolutely. And, a lot of times people balk at fees and, we're not trying to race to the bottom in terms of, okay, well, people ask us all the time, well, so-and-so gave us a lower rate. Okay, that's fine. This is my rate and this is what I charge for what I do. And I think it's worth it because other people are paying it. But if you don't, that's fine. And you can figure it out. But no, it's definitely interesting when people don't truly appreciate the value of folks who do this every day. But we've said that a million times. We've seen it all. I've seen just about every permeation of what can go wrong and the traps for the wary, and there's a lot of them.
Yeah. Now I want to circle back now and let's talk about more specifically, are there any cases or situations you have way in the past, that are maybe instructive to people, like that kind of teach a lesson or give us some insight into maybe things to avoid or things to do?
So a lot of time is spent talking about avoiding probate, right? People think it's a dirty word. That's fine. And there's all sorts of ways that we can deal with that. One of which is transfer on death deeds that transfer property immediately to folks upon someone's death. And so now we have a bunch of co-owners, or maybe there's an heirship. And for whatever reason, we don't have an administrator or a executor of an estate, but we have multiple people who now own a piece of property together. If someone files a partition and you are not the surviving spouse of the person who has died, there is no point in fighting it. There's just not. Because you cannot be forced to co-own property with someone you don't want to own property here in Texas, with the caveat that a surviving spouse does have the right to live in a house for the rest of his or her life. And people don't understand that. I've had cases where at the end now no one really gets anything because of that, because there's so much. We have to have a receiver appointed and everything, every little piece of the process just eats up the administrative fees, just eat up all the equity. And then, along those same lines, trust but verify. So I had filed a partition action. This was years ago. It was my client and her brother owned the property. Her brother convinced her that his attorney was going to be cheaper and he wasn't going to fight the sale of the property. So she fired me, which is fine. I fire clients. They fire me. It's all within our purview. Well, then 2 years later, she reaches out because guess what? Her brother wasn't being honest with her. And once they got me to dismiss the partition, he didn't agree to sell the house. And so now she had to repay all those filing fees, repay all of the fees to get the partition going again. And if she had, and what I had warned her when she was like, just dismiss the lawsuit, was, hey, y'all can sell the property and we can keep this pending. And let's wait until the money is in your bank account before we dismiss this partition. Or until the title company tells us, okay, you have to dismiss this partition before we'll close. But if you don't trust somebody and they've been acting a certain way, don't decide that it's worth it to save a couple $100 or a couple $1,000 and then put yourself in a situation where you have to start all over again 2 years later. Another thing I would tell people is there is a misconception out there that people will just figure it out. That's not how that works. Grief does weird things to people. And also at the end of the day, people are scared for their own financial security and that makes people do crazy things. So I'm trying to just pick one, but there's just so many. I think that sometimes it's hard to make this change in your brain, but especially when we're just fighting over who's going to administer the estate, you really got to think about it from a business point of view. And yes, your loved one appointed you to be the executor or the co-executor of their estate. But at the end of the day, if it's just going to result in less money going to different people because we're going to be sitting here fighting and getting dragged back into court because they don't like that you did this thing or that thing, have a third party do it. Don't let your pride get in the way of a sound business decision. Especially in this line of work, people say well, it's the principle of the matter. My loved one really trusted me to carry out their wishes, or what it was, my husband, and I really want to make sure that I wrap things up for him. Principle is expensive, and it's not a good way to make those types of decisions. You need to really turn on your business brain and think about what makes the most sense.
Yeah. And that's hard. I had a clinical psychologist on this program, and I don't know if you saw that episode, but she's like, I think episode number 3. She had some very interesting insights. We were talking about grief and loss and the psychological effects of that on people, and how she actually told a story how when her own mom died, she was like doing something. She had done some grocery shopping, and she had left her keys in the freezer. Her mind was just elsewhere, right? So she's just not cognitively functioning at the highest level. And we were talking about how, decision making and how these things are affected. So it's very interesting. It's almost like very similar, I think, to what people probably experience in family law, where it's like very emotional. And you bring up a good point, right? I liked what you said. Principle is expensive. And that makes a lot of sense to me. I'm wondering, looking at it from the perspective of, before probate, before things can be contested. I mean, does it all come back down to just having a great plan at the beginning of, before starting out? Or does it matter? Can it be you have the greatest plan, but you still run into these problems?
I think that having a good plan is a really good place to start, and it can definitely deal with 99 of it. But at the end of the day, there are going to be people who are dishonest. And I had a case a couple of years ago where mom had a plan. She had one child. That was it. And she got cancer that metastasized to her brain. And I don't know if you don't have experience with someone with a brain tumor, towards the end, it's not pretty. There's not a lot of vocalization. There's not a lot of real communication that can happen. Maybe just a week before my client's mother passed, another family member swooped in and had her change the beneficiary on a multi-million-dollar Edward Jones account and signed a new will that divided things up into theirs instead of it being all going to the child, which is the way it had been for the previous 20 years. You can't plan against that. I mean,
Right.
You can, but at the end of the day, people are very, very good at finding some traps. Now, that is obviously not your average case. I would say
That's why they need you. They need you for the not average cases.
I would say 75% of my contested or dependent administrations could have been avoided with a will or something in place. But there's about 25% of it where, we did have a will, but the siblings just hate each other so much that they don't dispute where the property is going to go, but they dispute who's going to be in charge of doing it. Or I've had some iteration of this case twice, and interestingly, I've had to argue both sides of it, but where mom decides that she's going to move onto a property with a sibling, and so she starts building a house on that person's property, but they don't necessarily document anything properly. And then halfway through the build, mom dies. So who owns that property? Who's responsible for finishing that build? And that's just a thing that people don't think about that will even happen. Even in my own family, my in-laws floated the idea of doing that for my mother-in-law's parents. And I was like, okay, well then if you want to do it, that's fine. But we need to have a contract. We need everyone to be on the same page, because you just don't know what's going to happen. Then, and even if that house is finished, okay, who does it belong to? Is the person, so there's a lot of stuff like that people don't realize will cause an issue. So they may have a valid will, but then they did this side deal because they knew that they weren't going to live independently forever.
I believe it or not, I've heard about this situation of someone building, the land is owned by one person and then another family member is building on that land. I've heard a variation of this before. That must be more common than I had previously thought.
It's fairly common, especially for folks where the loved one died kind of unexpectedly, because they think that they're going to have, they'll have time to figure it out in the future. So yeah, no, I've had to argue literally both sides of both representing the family member whose house or whose property the house was on, and the family member who's mad about the loved one's money being used to enhance a sibling's property.
Yeah, that's very interesting. We're heading almost into an hour of our conversation, and we try to make them about an hour long, so we can really get as much value from your experience, so we can share it with our audience. As we're kind of winding down our episode, I usually like to ask our guest on the program, if you had like one piece of advice. So let's just say there's someone listening to all of this, and this is your chance to have a bullhorn and just to tell everyone what you think. What's a piece of advice, or what are a few things that you just really feel, just based on all of your professional experience, that you feel like this is something that I really wish people would just like get their head on straight and do it?
So it's going to come down to any will is better than no will. And people spend a lot of time worrying about I want to make things fair or things like that, and really just get something down. Anything is almost better than nothing. Let me put it that way. And also, it's always good to plan ahead. The best time to plan is before you're in crisis. And this is one of the things that folks struggle with mentally, is they don't like talking about death and they don't like talking about incapacity, but it's coming for all of us. So you might as well start now and change it and update it and do those things, because you do not want to be making these decisions after you've already received a diagnosis, or heaven forbid, after you've gotten hit by a truck and you can no longer make any decisions because you have a traumatic brain injury, and we have to have a guardian appointed to deal with your property and sell your home so you can move into a nursing facility. So get something down. You can always change it. My other big piece of advice is think practically about family dynamics. If your stepkids or your children have never gotten along, the first time they get along is not going to be after they've lost a loved one. It's not going to bring people together. That's not how that works. And people think that it will, or they just trust them to do it to honor their wishes. Well, that's just not how it works. The normal thing is that it won't. It's actually going to make tensions worse after you lose a loved one. So any will is better than no will. Think practically about family dynamics and get something down.
Love it. I love it. I want to thank you very much for spending time with me here on the Texas Probate Real Estate Podcast. The most valuable thing we have in life is our time. We don't get any of it back. So I really appreciate you being so generous and responding to us, and to have you on as a guest. I think you shared a lot of interesting insights that we actually have not had on the podcast, and I want to really thank you for that, and thank you for those final words. And we definitely want to make sure that anyone who is listening to this podcast or finds us either on Apple, Spotify, or YouTube, that if they need someone that is dealing with an issue in your wheelhouse, that they have an opportunity to connect with you. How can people find you?
So my website is easy to find. So it's thehaneylawfirm.com. So THE, like the haneylawfirm.com. And all of our contact information is on there, as well as more information about our team and the services we provide.
That's awesome. If someone's considering to reach out to you, is there anything that they can do in advance to make it more productive in that initial meeting with you? What does that look like?
So the very first question that's going to be asked before we even have a consultation is who is involved, so we can do a conflicts check. So having that information ready to go, assuming there is no conflict, any important documents or records or paperwork, it's always really helpful for me to see that beforehand. That way my clock's not running just for you to watch me read. Get it to me beforehand. That way I can look into it and double check property records and things of that nature.
Awesome. We're going to share all of your information so that people can reach out to you. Thank you very, very much for being on the program. And if you've been listening or if you've been watching, please reach out to her if you have any problems with your probate matters. And I want to thank you very much for listening and watching. This is the Texas Probate Real Estate Podcast. My name is Jeremy Kritt, owner and broker of Kritt Real Estate. If you have real estate in probate that you're thinking of selling, give me a call. Don't just call those investors that are probably reaching out to you trying to buy your property for pennies on the dollar. I will show you a proven plan to sell your property quickly and profitably. Thank you for watching, and see you on the next one.